Can I remind members, visitors and those in the public gallery to please ensure their mobile phones are switched off or in flight mode for the duration of this meeting, as they interfere with the broadcasting equipment even when on silent mode. I would like to welcome Mr Vincent Jennings, CEO of the Convenience Store and Newsagents Association, Ms Tara Buckley, Director of RG Data, and Mr Tommy Smith, HR Consultant with RG Data, and also Ms Lorraine Higgins, Head of Public Affairs and Communications for Retail Excellence Ireland, to the second session of this meeting on the Banded Hours Contracts Bill. I'm sorry for keeping you waiting. Our first session went on quite a while. Before we commence, in accordance with procedure, I am required to read the following. By virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. If you are directed by the committee to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of these proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any person or persons or entity by name or in such a way as to make him, her or it identifiable. I would remind our guests that the presentation should be no more than 5 minutes duration. We already have had the briefing documents circulated to us, so if you could keep them short, it would be appreciated. I now ask Mr Jennings to make his presentation to the committee. Sorry about the lowish numbers, but there was a vote in the Shannon. They will be filtered back to us in a couple of minutes.
Thank you, Chair. I welcome the opportunity afforded by the committee to the Convenience Stores and Newsagents Association to present on this private member's bill. The CSNA is not anti-employee or anti-trade union. It has never supported any political party and recognises the efforts made by the drafters of this bill to address what they perceive to be a particular problem with regard to the difficulties encountered by some workers in securing less precarious contracts. Our written submission set out our response to the 5 specific matters for consideration that the committee requested. I don't intend to reintroduce these matters, but obviously I'll cover any queries that either the Chair or members may have. With regard to this bill, we would take the attitude that every bill, whether government-sponsored or a private member's bill, should be accompanied by a regulatory impact assessment in keeping with better government principles as adopted over a decade ago. An RIA would analyse the cost implications for business, particularly small businesses, and consider alternatives to legislative intervention. It would also examine the size and scale of the problem, something that the University of Limerick study lamentably was shy on discovering. An RIA would also seek to meet all relevant stakeholders in advance of progressing toward a bill. We understand that this bill has not had the benefit of employer consultation. CSNA does not believe that the committee's pre-legislative scrutiny is the correct approach for devising coherent and competent legislation, as it is dealing with a published bill rather than being involved in creating legislation. CSNA does not accept that additional legislation, which by extension places additional regulatory burdens on an entire cohort of employers, is an appropriate or necessary response in the absence of evidence that would quantify a problem that could only be resolved by the introduction of new laws. This bill is one-sided in its direction, and it suffers from a lack of appreciation of the employer's perspective. It seeks to increase the rights for workers by way of increasing obligations on employers without any provision to offset these obligations if and when their businesses require urgent attention. It does not make provision for how anomalies and unforeseen consequences that would follow from this bill, if enacted, would be addressed. A worker returning from maternity or extended sick leave will quite legitimately expect to be able to return to the position that they had held prior to their absence. How will these returns be accounted for if the workers that had filled their hours had demanded to have their new banded hours contract to replace the hours that they had worked? Many of our members employ workers in the evening, at weekends and on public holidays. The bill makes a crude reference to hours worked without considering the nature of these hours. If a worker seeks an entitlement to receiving a new contract based upon hours worked in the preceding 6 months, there is no restriction or obligation that such hours will be restricted to similar periods as previously worked. It has the potential to restrict flexibility. The business model that our members adopt requires very significant elements of flexibility to meet an ever-changing retail environment. Convenience retailing extends across a substantial portion of the day, from as early as 6 in the morning to as a minimum 10 in the evening, 7 days a week. There are, within each week, significant peaks and troughs. Local events can and do create the need for extra or fewer hours. These events are not predictable, nor are they constant. Granting an employee the right to be employed based upon the previous hours worked displays a lack of understanding of our businesses and the ever-changing nature in this most challenging environment. Banded hours are most certainly one of the ways that some employers can regulate their businesses. They cannot be applied to all employers who, by virtue of the size or nature of their business, need a greater degree of flexibility, whether for seasonal, structural or financial considerations. Finally, the CSNA is very conscious that this bill, if enacted, would create the potential for substantial additional costs to our members if they are involved in interaction with the Workplace Relations Commission and the Labour Court. These costs are not limited to the cost of engaging legal counsel. There are also costs associated with responding to the Commission, attending the adjudication hearing and to the Labour Court. There are also additional costs involved in the provision of easily read notices of an unspecified number of languages. These have to be accessed, approved and completed at a cost to every employer in the state. We consider such obligations to be unnecessary and disproportionate. Thank you, Chair.
Thank you very much. Now, Ms Buckley, if you would like to make your presentation. Thank you.
Thank you very much. Thank you for the invitation to appear before your committee to discuss this private member's bill. And I'm joined by Mr Tommy Smith, who's a HR expert with great experience in assisting RG Data members and other retail employers. RG Data represents family-owned independent grocery retailers in Ireland. Our members own and operate over 3,500 shops, convenience stores and supermarkets in every community throughout the country. They're significant employers providing vital, local, full and part-time jobs in cities, towns and villages all over Ireland. It's a fact that independent stores have a far greater employment intensity than the multiples. The independent sector has a 35% market share and employs around 90,000 people. The multiples have 65% of the market and employ about 35,000 staff. Lidl has an average of 20 workers per store and Aldi maybe around 24. The employment intensity at an equivalent independent grocer is between 50 and 120 employees, so very important employers right around Ireland. The split between full-time and part-time workers is about 50-50 within RG Data members' shops. This reflects the cyclical nature of convenience retailing. Some days are busier than others, and some periods within days are more active than others. Employees in RG Data members' shops are issued with a contract of employment stating the hours they've been employed to work. The contract includes a flexibility clause